Welcome back, everybody. We're here with Mike Kuna from Kuna Law Firm, PLLC. Good morning, Mike.
Good morning, Ashlyn.
We have an interesting question. This week's question is, for the past 3 years, I have been suffering from my ex-wife in regards to my son. She received primary custody in the divorce, and she has not been following the guidelines of the order. She's telling my son that I'm a bad father and sometimes will not let me see him for 2 weeks at a time, and then suddenly allows it again. I'm so fed up with her, and I need someone to fight for me.
Well, Ashlyn, this is one of these cases that should have been resolved 4 years ago, not 3. Now, I'll explain why. You need a good lawyer to advocate for you in the initial divorce proceedings or the parenting responsibility proceedings. That way you have a favorable decision to begin with. Now, throughout these proceedings, before these proceedings, and after these proceedings, I recommend my clients to document everything. And I'm telling always to my clients on a daily basis, you know what, think you have an OCD. Open up a Microsoft Word document and write down every single incident that happened to you. And when that incident happens, gather more and more evidence, screenshots, photos, video recordings, voice recordings, to avoid any unnecessary burdens upon yourself. Why? Because if you have that evidence and your ex-wife would have done anything of that sort throughout the period of these 3 years, you could have filed a motion for contempt and asked the ex-wife to pay for the attorney's fees and costs in court, and the court most likely would have granted your motion. Regardless, if you have such evidence, you can also file urgent motions and restraining orders. This case has gone too far, and usually it goes further and further when the party that disobeys the court orders is not given any consequences for that disobedience. At this point, it's been 3 years that passed, and after 2 years, the court can actually modify parenting responsibility. Now, the court requires 2 things to modify parenting responsibility. First, we need to have a change in circumstances that is not usual. It actually needs to be a big change in circumstances. I believe this repeated contempt of court and other circumstances that might arise in this case do warrant that change of circumstances. Second, no matter what happens, the court will always consider the benefit of the child and what's best for the child. Now, when the court considers the best for the child, the court will go through a list of different factors. Some of these factors do include whether the first parent supports the relationship of the child with the second parent, whether there are issues of domestic violence or not, whether any parent out of the 2 filed frivolous motions or made accusations about hurting the child that never existed. Also, specifically about the moral stature of the parent, as well as the physical and naturally the mental health. But the court will still concentrate on factors such as the parent's emotional connection with the child, the love and guidance that the parent gives to that child, the child's schooling, the child's developmental needs, whether the parent can provide them, whether the parent can provide medical care, shelter, safety, food, clothing. All these things are discussed within these factors. Now, once we've proven we have a material change of circumstances and it is in the best interest of the child for that parent to have the primary residential responsibility of the child, we also need to ask for an evidentiary hearing. I prefer evidentiary hearings. I like evidentiary hearings. You can annihilate a person on cross-examination within an evidentiary hearing and prove how many faults and sins that person has committed. To get that, we need to prove a prima facie case that parenting responsibility should be modified. Now, as you well know, Ashlyn, this is not a criminal case. So we don't need to have the standard of responsibility called beyond reasonable doubt. This is just a bare minimum standard of responsibility, and within that standard, all we need to prove that if the court modifies the parenting responsibility, that modification will stand an appeal proceeding. Now, I'm trying to make this short, but this is a very complex legal issue. It should be discussed for far longer, and I would prefer it if the person in question would call me so I'll be able to explain the full legal standing behind my words.
Okay, do you want to provide that phone number really quickly?
Yes, 701-404-7768.
Okay, insightful. If you want to submit a question yourself, you can go to the Valley News Live website, click on the Ask an Attorney tab, and simply fill out that form. Thank you this morning, Mike.
You're welcome.
All right, everybody, we've got more coming up. Your daily dose of motivation right after this break.